thing. No, that's not how it works. There is a process of proving the will. And this is where I'm going to spend most of the time because a lot of persons, they don't understand this. And I think that is the reason why people killing people after will read because they think said this and that and whatever. No. So when you pass away and your will is read or whatever, the executor then has the duty to prove the will. So how do they do this? They file an application in the Supreme Court for a grant of probate, right? So what this grant of probate is basically saying is that such and such will was signed by such and such a person on such and such a date, and the court declares it to be authentic, they declare it to be a valid will, and they give you the power now as the executor to administer the assets in the estate. Clear? But don't think it end there. No, my friends, it does not end there. So after you get the grant of probate, you have to pay what we call death duties. Yes, even when you're dead, you have to pay taxes, right? And death duties is 1.5% of the gross value of your estate. So if your estate is 30 million, you're forking out 1.5% of that to the government for your death duties, right? But if your estate is, if the estimated value of your estate is below $2 million, you get an exemption from debt duties, right? But we know realistically a lot of persons don't get to benefit from that. So what do you do in situations like that? You have to put some money aside because you will find where your executor is strapped for cash. They just bury you. You probably have some other things to take care of, and there is no money to probate the will, right? So you have to take those things into consideration. Also, you must get the advice from an attorney who can help you with the probate process, because I can tell you, it can be very technical. I give you an example. If you write your will, so you physically wrote it, right? There'll be times when you make your application for probate that the registrar of the Supreme Court will say, hey, this handwriting looks shaky. I don't know if it really belongs to the person who dies. And we call that person the testator, right? So the registrar may say, this handwriting, I don't know if it really belongs to the testator or not. And they will ask for what is called an affidavit of handwriting. So what that is somebody who knew you when you were alive, knew how you write, have to sign now a sworn statement to say, listen, I know John 20 years, and I saw John write, and it's John handwriting, right? There will also be cases where, for example, your will is not kept, say, in a place where it is protected. So say, for example, now, a little hurricane come, a little watermark get on the will, and you submit that to the Supreme Court. They will then say, listen, this watermark thing looks shaky, explain how this got on the will. So you can see what I'm saying, that it can be very technical to prove the will, right? So then in a situation like that now, your attorney then has to find out some information from you. John, where was this will? What happened? Water touch it what? And then they now will have to do an affidavit for you to sign to say that what is called an affidavit of plight and condition, which indicates that, okay, when we got the will, we kept it in whatever place, but rain fell. This is why this watermark is on it. And we state that it is still valid. It is what the testator wrote, and they signed to it. Clear? Right. So, as I was saying now, after you have received your grant of probate, the next step now is to take that grant to your different entities. So, for example, if it is a bank account that you now want to access, you will take that grant of probate to the bank along with the person's death certificate and say, okay, Mary Jane is now passed. We have proven her will. Here is the grant. Here is her death certificate. Give us access to the account, right? No, remember, if you are an executor, you hold whatever assets that the testator has left in the will on trust for the beneficiaries. Now, many times an executor can also be a beneficiary, right? But the executor has what is called a fiduciary duty. So what that means, they must act in good faith. They must act for the benefit of the beneficiaries, right? So in other words, you put the beneficiaries above yourself, even if you are also a beneficiary. I give you an example as well. An executor holds property on trust for the beneficiaries, and one of the testator's wishes was that the property would have been rented, right? So that rental income would have helped with, as I said before, the expenses of proving the will. The executor did not fully understand his role, and so he spent all of that rental income. When you do that, you would then set up yourself to be sued, right? And bear in mind, an estate is somewhat treated as a business then, right? An estate has to get its own TRN because, as I said before, you have to pay your debt duties, right? So just as how it can, you must get a TRN, an estate can also sue, and it can be sued, right? So what happened to that lovely executor? He was sued, and he had to somehow find that money to give back the beneficiaries. So, as I'm saying, that person must be an honest person. They must fully understand what it is they are, the task that they are given, and they must act in accordance with their fiduciary duty, right? Fine. So, after you have proved the will, we dealt with bank accounts. Let's talk about land now. So after you have proved the will, your next step is to move on to what is called the transmission and the registration of the beneficiary's name on the title, if it is registered land. So what that means is that after the grant of probate is granted, you would then get a TRN for the estate, which your attorney will assist you in doing so, and then you sign what is called an application on transmission. So what that document does now, it allows the registrar of titles to put on the title that Mary Jane has passed away, and the executor is now noting that on the title, basically, right? And then through doing that transmission now, so in other words, the property is then transferred to the executor, right? But it's not for the executor, as I've explained to you, because the executor holds it on trust. So the executor then now has to sign an instrument of transfer in favor of the beneficiary, right? So that's the second stage of the process. So before you get there, you have to get what is called a stamp commissioner certificate or a Form 8. And you cannot get that unless you pay your debt duty. So you see where the government is ensuring that they get their 1.5%, right? So after you have secured your Form 8, which is your or stamp commissioner certificate, both names is the same document we're referring to. That document is then now passed on to the registrar of titles. So we have two major offices that we're dealing with. We're dealing with the stamp office, and we're dealing with the registrar of titles or titles office, right? Those documents now, so your Form 8, your transmission document, application for transmission and your instrument of transfer, those documents are then lodged at the titles office. You pay your registration fee, and then the registration is done on the title, right? So that is when the beneficiaries know they will get their names on the title and they can go on their merry way. They have now acquired a new property. Clear? Right. So I've touched on your executors, I've touched on your beneficiaries, I've touched on the process. Now, I feel the need to talk about if you don't have a will, because many times persons decide not to make a will, right? Which for whatever reason, for expense, whatever. But to be honest with you, in both cases, it can be problematic, whether you do decide to make a will or if you don't. If you don't decide to make a will, then no, we look to statute, right? Which is the property charge, the Intestates Estate Property Charges Act. So in that act, it tells you who can apply in an order of prior administration. And they have the same effect, right? But the only difference is that because there's no executor now, whosoever applies and get that grant of administration, they have to reserve the right for the other persons on that order of priority to get what they are to get. I'll give you a practice. Behind the children, you have other relatives and friends. And this is where persons now will war, basically. Because they're saying that, listen, I want X, I want Y. But as I said, we look to the statute, which tells us what and what, and it literally tells you what each person can get, right? A lot of persons too may not want to go to the route of getting an attorney because it is expensive. Attorney's fees for either application is 5% of the value of the estate plus GCT. So it's 5% to get the grant or the grant of probate, grant of administration, and then the process that I told you about getting the transmission application, that is another 2.5%. So as I said, whatever route, please try to get your affairs in order in terms of money to assist with the actual process, right? So, as I was saying, I give you a practical example. Husband passes away, and wife